I call Dr. Deborah Russell.
Madam Speaker, New Zealand is a small place. We all know each other. In fact, somewhat worryingly, we might even all be related to each other. And it has its problems. But one of the things that the smallness of our community entails is that it's easy to connect. It's easy to cooperate. It's easy to collude. And that's when you get a cartel. You see, on this side of the House, we support that connection. We support the cooperation, but we draw a line at collusion. And it's a firm line. That is behaviour that we think must be illegal, and it's behaviour that in some circumstances warrants being criminalised. And that is why we have brought this bill to the House, to stop collusion. Now, you know, what we're talking about here is about cartels, about groups of businesses colluding to price fix, to restrict output, to allocate the market in particular ways, all in order to get a greater profit for themselves. It's business misbehaviour. Now, as members on the opposite side of the House have pointed out, well, no, business misbehaviour is usually just a civil matter, something that's dealt with by a fine, a penalty, maybe a period of time when you're barred from trading. And that is what a civil penalty is for. It's because it's not criminal activity. But there is something a little bit more when it comes to collusion. And that's because collusion is not just a civil matter, it is a moral matter, and it is a moral matter because it is theft. And that is why collusion needs to be criminalised. It's interesting how, you know, this collusion can come about. And I was very, very interested to listen to what Mr Carter had to say about the National Animal Identification Tracing Act in 2012, where it seemed that almost inadvertently stock companies had talked to each other, they'd arranged a few things, and in that way they had come to cooperate in such a way that it became collusion. And in fact, the word that Mr Carter used was inadvertent. And that does happen. It's a known phenomenon, a known psychological phenomenon, something that's studied in depth in game theory of the ongoing tit-for-tat, where people sort of develop a strategy of cooperating with each other until, in fact, they are colluding. And it is done inadvertently, and that's where you would have a civil penalty. And we've got civil penalties for that kind of inadvertent behaviour. We've already said, and in fact this is in the legislation already, that in terms of the civil penalty, it's a fine of up to $500,000 for a person who's involved in cartel activity and $10 million for a company. But we need a stiffer penalty, and it's a much more serious penalty where intent is involved, where people set out to defraud, to steal, to price fix, to market allocate, to take money from their fellow citizens and enrich themselves, to undermine the market in which members on the other side of the House so often profess to believe, only when it suits them, it turns out. You know, one of the things about this collusion is it's very hard to see. The people from whom money is stolen are dispersed. It's often individual consumers who perhaps only pay a small amount each, but the effect is large. And again, that is why this needs to be criminal behaviour. But imprisonment. Imprisonment is a harsh penalty. Now, normally we think that it would be a good idea to keep people out of prisons. Normally we don't like to incarcerate people. Taking away someone's freedom is the most serious punishment we can have in this country. So why on earth would we do this? Why would a civil penalty not be sufficient? And interestingly, members on the other side of the House gave us this answer themselves. They were the ones who made the point. And I think it was Mr. Bailey who said that there were hundreds of cases under the law as it stands. Now, surely that proves that if there are hundreds of cases, that the law is not working, that the law doesn't have a sufficient penalty. It seems that existing businesses regard those fines and penalties just as a cost of doing business. They can stand a fine of a few $100,000 if it gives them a much better market position. So we need to find a way to signal clearly to businesses that they must not engage in this behaviour. We need a serious penalty, and that is the criminal legislation, the penalty that we are putting in place. You know, the theme was echoed by Mr. Yule, who said that there was no robust case for this legislation. But if there is no robust case for this legislation, why is Mr. Bailey telling us that there are in fact hundreds of cases? It would be pleasant if the members on the other side of the House actually cooperated at least a little to sort their arguments out. Now, Mr. Bailey also said that in fact that we were introducing a very, very grey area into the law, that we would just sort of incentivise lawyers, we would give them a great new money-making field. Mrs. Kuriger said that we were walking a tightrope, that we were making things very difficult for businesses. You know what? It is difficult. It is hard. Being in business is a difficult game, but just because it's difficult doesn't mean you're allowed to be criminal in your behaviour. So we actually need to make sure we penalise the behaviour. Mrs. Kuriger also raised another issue which I thought was very interesting. She talked about the compliance costs that businesses would bear because of this change in the law. But may I point out that businesses already bear these compliance costs. There are already civil penalties in the law. Businesses are already required to assess whether or not their behaviour is acceptable under the law. The difference is they seem to have ignored it. That's why we need to have the criminal penalty. And let's be quite clear, this legislation has measures within it designed to reduce those compliance costs. A business may go and seek clearance to ensure that their behaviour does not fall within the bounds of this law. They can get clearance in advance for their connected, collaborative activity. They just may not collude. That's the difference. And I think there's something else that I really want to draw out in respect of this legislation. On this side of the House, we have talked about the cost to consumers of collusion between big businesses. We've talked about how each of us as individual consumers end up paying a higher price because of collusion, because of cartel behaviour. But it is not just us as consumers who pay this higher price. The businesses who collude, who engage in cartel activity, don't just steal from consumers, they also steal from honest businesses. They steal from businesses who want to play by the rules. They steal from businesses who are doing the best they can and are playing within the law. You see, those businesses make reduced profits or less profits because some people cheat. Let's be quite clear, this legislation is about stopping the cheats. And the bill ought to be supported by the alleged party of business on the other side of the House. Madam Speaker, I put it to you that the true party of business is the party on this side of the House, the Labour Party, which seeks to ensure that honest businesses do well and that dishonest businesses are stopped in their behaviour. This is what this bill is about, and it is why we should support it. And, you know, we are hardly alone in doing this. Our major trading partners, countries that we normally like to compare ourselves with, Australia, the US, Canada, the UK, France, Japan, they've all got a criminal offence for collusion. There is no reason why we can't do it too, and indeed it is something that supports ordinary people and it supports ordinary, honest businesses. So it's hardly an unusual provision that we're putting in there. And for these reasons, Madam Speaker, because we are supporting the honest businesses, because we are supporting the little people. That is why I urge this House to support this bill.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party vote is called for. The